to another edition of Ask Michael Ehline. This is where I teach people the law in an unorthodox manner by using examples that we see in the news, case law briefs, but it's all about exposing the Leviathan and its instrumentalities and taking back your rights. Know the law and mean to keep it well. Come here to learn from an expert to know your right. Make sure to like and subscribe. Make sure to save, because we never know when the thought police are going to take down this channel.
That's right. We never know when the thought police are going to take down this channel. How's it going, guys? I am attorney Michael Ehline. Just give me 1 second here. I'm just trying to dial in my sound and everything. As you guys know, I kind of blew my back out, so it's been kind of rough getting in to do these shows. So hopefully y'all can hear me. Hey, Jody, good seeing you. What's the matter, you? Hey, nice seeing you, brother. Give me some 5x5s if I have some decent sound, guys. Let me know. Hey, Brandy, how you doing? Thanks for supporting my show, Brandy. Brandy's always trying to help me sell my book about how to become a lawyer with no law degree or undergrad. I appreciate that. Hey, what's up, Dawood? How are you? And Ryan Labs, yeah, Ryan Labs made it first. Ryan Labs wins the prize for being the most motivated devil dog. So, guys, just give me 1 second. I'm trying to just dial in a couple of things on the trying to dial a couple of things here on my YouTube channel before we get too crazy. Trying to put in all my hashtags and stuff so you guys can find me for later. Forgot to do that because I've been out of practice. I've been on gabapentin with a blown out back, so just trying to get back into the groove. But I miss seeing you guys. Just give me 1 second here. And that should be it. All right. Okay, so how's it going, everybody? I am attorney Michael Ehline, and I am an attorney licensed in California and Texas. And I've done quite a few defamation cases in my time. And I am an expert. I've been practicing law for over 20 years. I've won some SLAPP, anti-SLAPP appeals, and this is a case about defamation, and this is actually a defamation per se case, and I'm going to teach you guys how I would do a deposition in the state of California. So again, this is not legal advice. You know, whatever I do, if you're not a lawyer, you need to check it out yourself, do your own research. And none of the views that I express here have anything to do with Ehline Law Firm or any of my associates or partners or people I work with of counsel. This is something I do for fun to try to teach my kids how to be entrepreneurs and help people like you understand the law. And so defamation is a tricky thing. And so I thought I would let you guys actually go through a defamation deposition with me. And I would use one, instead of a cop, this time we're going to use Steven Crowder. So Steven Crowder is a famous conservative comedian, talk show host. I think he's got a channel called Louder with Crowder. And I think I check him out sometime. I think he's a pretty cool dude. I have no issues with the guy at all. So I'm not here to try to go after him or anything. I'm actually going to approach this deposition as if I was his lawyer. And I'm going to teach you the way that I would object. And again, if his attorney doesn't object the same way that I would at his deposition, that's fine. I'm not putting her down in any way, shape, or form. I think he had an excellent attorney. It's just that I have a totally different style because of my background in appellate law. And I really like to hammer home my depositions, my objections at depositions. So before I start, I know we did a cop deposition the other day, but I'm going to just break down what the law is. Now, I'm licensed in California and Texas, but we're going to do this. I'm feeling a little better, Gloria. Thank you. And good seeing you. What's the matter, you? Good seeing you life under the microscope. It looks like a lot of you guys don't like him. So a life under says he thinks he's a cuck. Everybody's entitled to their own opinion. I think the guy's kind of funny. Let me see what else we got. I have a company giving me veiled cryptic threat of misrepresenting them on one of my YouTube. Yeah, well, that happens, Ryan Lab, and so it's important for you guys to learn what defamation is and how to deal with it, because statements of opinion are not actionable. So if you qualify your statements like, I think this person is a cuck, or I think this person is a rapist, or I believe in my opinion, right? That breaks it down from a statement of asserting a factual thing into a statement of opinion. And that's a First Amendment protected activity. But when you start making comments alleging, like, for example, these asshole pieces of garbage on these frauditor channels who said that I'm guilty of stolen valor and that I never served in the Marine Corps, or that I was dishonorably discharged, and these other idiots who say that I've been sanctioned by the state bar, those are all lies, and those are all actionable. And within the statute of limitations, I get to sue every single one of those mother effers. And so you guys need to be very careful what you say about people online in particular. And one of the defenses that would make it more difficult for you to be sued is if you had a really, would make it is if you were a public figure. Okay. If you were a public figure, then New York Times versus Sullivan would have additional things that would come into play to make it more difficult for you to be sued. And we'll get into that later. But I'm just telling you that if you're a public figure, it's harder for you to sue people if they make false statements about you, because you voluntarily thrust yourself into the public light. And so there's an additional requirement of malice, that the statement had to be knowingly made, had to be knowingly false, had to be like with a reckless disregard for the truth. Okay. So in this particular case with Steven Crowder, I don't think this guy was a public figure. I don't think that he voluntarily thrust himself into the public light. And so it may be easier for this attorney to sue Steven Crowder for making an allegation that this guy was a Nazi or something. So we're going to get into it, and we're going to let the deposition do its own talking. But at depositions in California, they're generally governed by California Code of Civil Procedure 2025.010 et sec. In other words, et sec, E-T-S-E-Q, like et sequitur means that there are also other sections and other things that that in combination help you, that you can use and that can help you interpret the section and whatnot. But a defamation case deposition is going to seek to gather sworn testimony relevant to the elements of defamation, which is a false statement of fact, published to a third party. Published means that it's either written or verbal, and that it's out in the public. So anybody, even if you said it to a neighbor and the neighbor republished it, the neighbor could even be guilty of defamation for republishing if they didn't make it as like news reporting. Like Mike Ehline says this. If they go out and just repeat what Mike Ehline says, they could get hit for it. And they have to identify the plaintiff, the person who's going to be suing you. And it has to be something that would cause harm to the plaintiff's reputation. So if you call someone a Nazi and you publish that to millions of people around the world, that could get them fired from their job. That could get people giving them hate mail, could even get them assassinated, right? I mean, give me a bunch of ones if you understand what I'm talking about. Now, it has to be made with fault, negligence, or actual malice if it's a public figure, or just a negligent statement. So it's better if the person suing you is not a public figure, because then it's just a negligent statement, even if you don't know if it's true or not, right? It doesn't even have to be reckless. Just if you say this dude's an asshole, that's kind of a statement of opinion. But if you say this guy's a serial rapist, or this guy is a nazi, that is not a statement of opinion. That is a assertion of fact. And you would have to have evidence proving that it's true. Otherwise, it's false. And in addition, that is defamation or slander per se. Like libel per se would be if it's written. Slander would be if it's verbal per se, which means damages are presumed. But it doesn't mean that you win your case. It just means that the damages are presumed. There's a rebuttable presumption of damages. But then again, you can rebut the presumption. So don't think just because it's defamation, slander, or libel per se that you've got a slam dunk case. You don't. You still have to prove all the other elements. It's just when it comes to damages, it's easier for the plaintiff to prove damages. Is that making sense so far? Give me a bunch of ones if you guys understand so far. Now, the questions are typically going to focus on the statement's content, context, intent, publication, and then the damages. You've got to prove damages. And it's hard to prove damages. They're not just even if they're presumed, you still have to be able to show what your damages potentially are. And so typically you've got to show payroll stubs, lost contracts. If you had a bunch of contracts, like you had a Nike contract, now you lost that contract, well, you're screwed, right? Like you can't make any money because someone called you a Nazi. So in that case, you could prove that they canceled your contract. You would bring in that other person who canceled your contract and get them to admit under oath that they canceled your contract because you were all over Fox News or something as a Nazi. Making sense so far? The typical depositions that you can make are objections to form. And a lot of lawyers, I consider this to be a lazy practice, will just say objection form. Well, I don't do that. I actually make and assert the actual objection because I don't want to leave it up to the appellate court to try to figure out what my objection was. Okay. Because form can mean a lot of things. It's vague and ambiguous if you say objection form, and it may be overruled, and you don't want your objections to be overruled. And your objections will be overruled later if it goes up on appeal, or if you want to bring that testimony into trial as impeachment evidence. You would have probably a sidebar away from the jury, or you would have the jury cleared out, or you would go in camera with the judge, and the judge would make rulings on those objections away from the jury, typically about the deposition testimony. And so if you just make objection form, when you could have said, objection argumentative, objection vague and ambiguous, objection compound, objection leading, there's a chance that the judge isn't going to rule in your favor on those objections, and they were all for naught. So you don't want to make stupid objections. Hey, what's up, Chevy? Good seeing you, man. Guys, read it, buddy. Give me a bunch of ones for Chevy. He's one of the few people who actually financially support my channel, which I really appreciate. And then everybody say hi to What's the Matter You. We got Chevy, Gloria Ad. Hey, all my friends here. I'm getting a lot of my buddies showing up today. Rhine Labs, thank you guys for all showing up and supporting the channel. Gloria Ad, yes, you're awesome. So I like to give recognition to my audience because I've been on a long journey with them. I'm part of Team Chili De Castro, right? And a lot of these guys are my buddies from his channel. And as you guys know, I was trying to help him out when he was falsely arrested and falsely jailed. When everybody in the frauditor community, the same people who have defamed me and lied about my status as an honorably discharged disabled Marine to many people, who I will eventually sue for defamation and slander, were saying that Chili was in fact guilty, that he deserves to be in jail. And I proved to all of them that I was right and they were wrong. And we really shut those assholes up. So, hey, what's the matter? You? Thank you, brother. Hey, what's the matter? You just gave a $5 donation to Team MPE. Right on, man. Give me a bunch of OTVOs in the sidebar for Chili, guys. And I'm really grateful that he's out of jail. I think that was really awesome. We scored one for parallel systems, a parallel systems community where we support one another, not because of our politics or religion, but because we support natural law. We believe in the concept that our rights come from an all-powerful creator and not the state, just like our founding fathers. And most of us support Doge. And by the way, I don't know if you guys noticed the audit of Social Security Administration the other day. Social Security checks being sent out to people who are 300 years old, 160 years old by the Democrat-run agencies. Like I've been telling you guys the whole time, they're basically like a crime syndicate. That's why they don't want voter ID, for the same reason. Because if there's no way to identify who these people are, they're not going to be held accountable. And they can just sweep elections, right? With a motor voter, letting illegal aliens register to vote, promising them free things in exchange for a vote. And that's what's been going on, guys. And it's all coming to a head. So that's why I'm so glad that I left the Democrat Party. Actually, the Democrat Party left me, and I became a libertarian. And I'm much happier not being part of a crime syndicate. Give me a bunch of ones if you agree. Now, other objections that you can make are objections to privilege. So if it's a confidential communication, attorney-client privilege, or it's self-incriminating under the Fifth Amendment, you can make an objection like that. But in a civil case, if you try to make a Fifth Amendment objection, I'm going to move to compel and seek terminating and doomsday sanctions. I'm going to try to have your defenses stricken, because as a general rule, you are not allowed to make Fifth Amendment objections in a civil case. Now, you can also make harassment style objections like objection, harassing, irrelevant, argumentative, asked and answer, so they don't try to get him to change or her to change their testimony, repetitive questioning. Now, objections like hearsay are generally unnecessary because they're automatically going to be ruled on by the judges. You can make those objections at time of trial, but I'll still make them during the deposition. But typically, you are not allowed under the Stewart case to make objections to relevance, because at a deposition, at least in California and Texas, and my understanding is in pretty much every state, a fishing expedition is what a deposition is. You're allowed to conduct a fishing expedition. Just because evidence might not be admissible at trial during a deposition, that doesn't mean that it might not lead to other evidence that is admissible, right? Like an example would be, tell us about tell us about the kind of motor that you have in your car, and it's a defamation case. Well, objection, that's irrelevant, right? That's what a lot of dumbass newer lawyers, especially like work comp lawyers who pretty much don't know anything about the law, as far as I'm concerned, when it comes to real civil procedure. They're sort of like in this administrative law black hole. They really don't know what they're doing when it comes to depositions. For the most part, based on my experience, knowledge, and skill, they'll make stupid objections like relevance. And it could be relevant. I mean, you ask him about his motor, and that could, where do you buy your parts from? And it could lead to a whole slew of people that he made a false or defamatory statement to in an auto shop. You just don't know. You could depose those people and find out that he was talking trash, calling someone a Nazi over there. So again, the judge might say, hey, that's not relevant. That's going to take too much time when you go to trial or even on appeal, but you preserve your objections for the record, for your trial and for your appeal. That's the point of making them. All right. Hopefully you guys understand so far. You're free to conduct it. That's right. What's the matter? You're free to conduct a fishing expedition at a deposition. That is very true. All right. So now, a lot of people say that you can now in a criminal deposition, you can definitely, you can argue Fuller versus Superior Court. You can argue the Fifth Amendment, but I've been able to compel that discovery and get terminating sanctions when people try to plead the Fifth, especially when they're bringing the case. So that's the difference. If you're the plaintiff in a case, and you're bringing a case against my client, and I start asking you uncomfortable questions and you want to plead the Fifth, well, the burden is on the party asserting the matter, right? The matter asserted, the burden is on him to prove every element of his case. And in this case, a false statement, knowingly false or negligently false, depending on the status of the defendant, damages, publication, right? All that stuff that would be part of a defamation claim. And I have the right to ask you questions that could amount to a crime, because that could help me be able to determine whether or not you're an honest person, right? Have you ever been convicted of fraud? Or have you ever bounced a check? Have you ever stolen money? Well, objection, Fifth Amendment. No, that could lead to relevant evidence, character evidence. So if you try to pull the Fifth Amendment crap on me, and you're the plaintiff, the burden is on you, the party asserting the matter. The burden is on the party asserting the matter to be proven. Hopefully you guys understand so far. All right. Trying to get you through this as quick as I can so we can have some fun. So now let me see here. Now I can file motions to compel statements, I can seek sanctions. Like I said, I can seek monetary sanctions, but I can go for issue sanctions, terminating sanctions. Like I can try to get defenses stripped out of your answer and make them deemed admitted. So you got to know what you're doing especially when you go up against me. Now you've got to make timely objections. You can't make them later. So that's why it's important to make them before the deponent answers. And sometimes it may seem rude that you're cutting them off, but you got to do it. But you always need to be civil as best as you can. Now, when a lawyer instructs his client not to answer, he better have a damn good reason, like attorney-client privilege, right? Other than that, in a civil deposition, especially when you're the plaintiff, that's going to be a tough one. Now, if you're the defendant, you might have a little more leeway when it comes to things like Fifth Amendment stuff, because again, you're not the party bringing the matter, but it's still going to be an uphill battle if I want to fight it. The idea is to ensure that the deposition transcript captures all the objections and refusals to answer accurately, because this is your record on appeal, guys. So, and the same thing goes with a trial. You got to make your objections, guys. It's no joke. There's a lot of lazy lawyers out there who don't get it. I'm glad that I have a background in appellate law and having externed for the California Court of Appeal, 4th Appellate District, under Justice Gary Hastings. I was able to learn an amazing amount of stuff, and I'm really grateful to him for allowing me. Very, very few people get to extern for the Court of Appeal, and I don't know of anyone on the law study program who's ever had that honor except for me. So give me a bunch of ones for me for having that great honor. Now, if the statement is substantially true, it's a complete defense. If you're talking about defamation, and that's Maldonado, that's Smith versus Maldonado. I'm going to share with you guys some case law really quick. Let me open this bad chicken up for you. Hold on. Let's get to it. Just give me 1 second, guys. Just want to open up the, all right. I'll drop this in here for you. So I'll drop in some case law for you. So that's to do with true. If the statement's true, it's a complete defense. Like if I make a statement about you that you're a serial killer, and you are, that's a defense to defamation. So you're going to lose. And then I'm going to turn around and I'm going to anti-slap your ass, and I'm going to get attorney's fees. And that's why I was telling everybody, like, Lane Myers probably has some good Judge Ball, he could sue Lane Myers if he wanted to. I don't know if he'd win for defamation, but his problem is going to be that the point of the anti-slap is attorney's fees. Like, I've had cases where I've gotten an award of huge attorney's fees on the anti-slap, and that's how you settle. Because now all of a sudden, oh crap, they're filing. So, by the way, a defamation lawsuit is also known as a strategic lawsuit against public participation, right? Because you're basically trying to, it could be argued that by suing someone, you're trying to silence them from saying things about you. So it's strategically trying to prevent someone from talking about you, from participating in public discourse about you. Do you guys understand what SLAPP means now? And then I can file, as the plaintiff, I can file an anti-SLAPP. Is this making sense so far? And then in that anti-SLAPP, if you have a lawyer, you can seek attorney's fees. And I charge $500 an hour. So I might spend 300 hours on that anti-SLAPP. And now that's chargeable to the plaintiff. So even if during the course of litigation, I can file that, and now the plaintiff is going to be saddled with my attorney's fees. And so it's a really, really big deal. So you got to be very careful. Now, with Lane Meyer, since he represents himself, I don't know about Arizona law, but in most states, you don't get attorney's fees. And that's why I was trying to tell Reluctant Prophet and Lane, you guys, man, get a lawyer to sign on so you can get those attorney's fees, because that would put him in a much stronger position to get Judge Ball's case tossed. He still got it. He still ended up dismissing the case against Reluctant Prophet because it was a BS case. And it was dismissed, at least parts of it, with prejudice. And a lot of the frauditor, low-life idiots who like to lie about all of us were saying, oh, well, it was dismissed without prejudice. Well, actually, guys, and by the way, that is a false statement, and it paints Reluctant Prophet in a false light by saying that it was dismissed without prejudice, because you didn't take the time to do the research to find out if you were right or wrong. There's just so many sheep in the frauditor community, a bunch of clowns. Give me a bunch of ones if you agree. All right, so here's another one, privilege. If a statement is privileged, like if it's made in a judicial proceeding, it's probably going to be immune from you being sued for defamation. And one of the things that could have been argued, hey, what's going on, BZ? One of the things that could have been argued by Reluctant Prophet is, hey, I'm repeating a statement that was made in open court. This is qualified as publicly made in court. It may not work, because you're now no longer in court, but you never know. Now, here's the thing, lack of fault. Now, public figures have to prove actual malice, and we discussed that earlier. I don't want to waste too much time because I want to get into this video. But public figures are going to have to prove that. So I just dropped that. I'm dropping little snippets for you guys. And then consent. If the plaintiff agreed to the statement's publication, that bars any and all recovery. So let me drop that for you. Comes the next one, guys. Dag nabbit. Here, I'm trying to get all these for you. Hold on. Wasn't able to get the full last one, but hopefully it's enough to where you'll be able to. Here. Hold on a minute, guys. Okay, here's the last one. You'll have to look up the citation. I couldn't get the whole thing in there. Let's see if this one works. All right. So, anyways, that's a California deposition. So let me get into now. Now, by the way, this deposition that I'm going to be showing you, this is Steven Crowder. This particular deposition, they're not showing you the setup too much. They're not giving you like his background. They're not doing the swearing in process. But before the depo starts, I'm going to lay a foundation, who this person is, what their educational background is, where they grew up. And in this case, I think it kind of starts off where they're qualifying his background. So I'm going to go ahead and start it. And then I'll object to it as if I was his defense attorney. So I'll be the attorney representing Steven Crowder. And I will do my best to not talk over his other attorney who does make some objections, but I'm going to be more aggressive because and it depends on the kind of case that you're in, but I want to create a really, really strong record because I presume that every case that I bring is going to go up on appeal. I never assume that I'm going to win at trial or that I'm going to settle. So that's the way I'll do it. All right, Ryan Labs, here we go, brother. We're going to get started. Boom.
All right. Today's date is August 26th, 2024.
Right,
the time is 1:31 p.m. Central Time, and we are on the record.
Mr. Crowder, if you'll raise your right hand, I'll swear you in. Do you solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you.
All right, sir, can you give us your name for the record?
Steven Crowder?
You are the founder of Louder with Crowder, LLC?
Yes.
Okay. Louder with Crowder, LLC is your media company?
Yes.
You operate a website and make internet videos?
Objection form.
Yeah, so that would be objection compound because he's asking two questions in one. So she's saying objection to form. I don't want to leave it up to the appellate court to decide what she meant by form. Okay, and now every jurisdiction is going to be a little different, and every appellate judge is going to be a little different, and every trial judge is going to be a little bit different. So the more thorough you are as a lawyer in properly objecting, the better for you. Okay, here we go.
Yes.
I'm just trying to figure out that's what your media company does.
That's part of it.
What else do you do that you would say that your media company does?
I would say objection overly broad, vague and ambiguous. It's honestly the question. It's not narrowly tailored enough. It's like, what does he mean by media company? Vague and ambiguous as to media company. But anyways, let's go.
General media company. So, yep, there's a daily program. There's a separate, reporting and investigative reporting unit, and the website operates separately where someone writes articles. So social media, kind of all-encompassing media.
Okay, so I've got internet. There's a daily show. Let's start there. All right, that's a video show, correct?
Objection, vague, ambiguous, and unintelligible as to video show.
Yes, sir.
And I know that it's also, you can get it in pure audio format too over podcast, right?
Vague and ambiguous as to podcast.
Yes.
Okay. As far as those videos, where would I see an episode of Louder with Crowder?
So, well, it depends, what point in time. So usually YouTube, Rumble, and then Mug Club, which is, operated under locals. But for a period of time, it would have been, and pardon me, I'm sick today, so if I cough, I don't mean to be distracting. Would have been under Blaze. So Mug Club was operating under Blaze at one point. You would have been able to see them on Blaze.
Okay,
And then
these are,
audio wherever audio is, available, like Apple, Spotify.
in other words, to see your show, I would watch it on the internet.
Yes.
You're not carried on any cable stations.
No.
Vegas to cable
You're
station.
not carried on over-the-air broadcast television.
Vegas to over the air.
Not today, no.
Okay. Do you have any licenses with radio stations, anything like that, to broadcast your show?
Vague and ambiguous as to
Not
license.
today, no.
Okay. Are all those answers same truth in May 2023?
I believe so.
Okay. Did you do anything to prepare for this deposition?
No, I watched, I had read the files that were.
First of all, objection, attorney-client privilege, number one. Vague and ambiguous as to prepare. You can answer the question other than anything that has to do with discussing any part of this with me. Do you understand, Mr. Crowder? Okay. I'm instructing my client not to answer anything that has to do with anything that he's done talking to me about preparing for this deposition. You can answer.
Sent over from your attorneys, well, yourself, I guess.
The files. Can you tell me what you mean by that?
The documents, the complaints.
Okay. In other words, the lawsuit that was filed.
Yes.
Okay. Have you reviewed any other documents to prepare for this deposition?
Not to my knowledge, no.
Okay. Have you viewed your May 8th or May 9th show?
I viewed at least a portion of it, yes.
Okay. And I'm mostly going to want to be talking to you about your May 8th show covering the Allen shooting. You're familiar with what I mean when I say your May 8th show covering the Allen shooting?
Yes.
Okay. Before I get into all that, I want to confirm some details on your background. As far as educational background, it's my understanding you attended a couple semesters of college.
Correct.
Okay. I think it's fair to say you have no educational background in journalism.
Objection. Vague and ambiguous as to education. Argumentative. What do you mean by education? You mean college? Can you be more specific?
No, I wouldn't agree.
Okay. Can you explain to me what your educational background in journalism is?
Same objection.
Years of experience?
Well, I'm asking specifically, we'll move on to your work experience. I'm talking about your education at this point, if you have any educational background in journalism.
Objection assumes facts, not an evidence. Objection, vague and ambiguous as to educational background. What do you mean by education? Are you assuming that you can only have an education? Counsel, are you assuming that you can only have an education if you went to some left-wing communist journalist school? Is that what you're asking? By the way, guys, what this guy's trying to do is set him up to make sure that he understands that a journalist, or anyone for that matter, who republishes something that's false, should know that they're not supposed to publish false information. So in this case, I would be trying to argue the opposite, that I'm not a journalist, that I really am just a comedian, and I don't know what I'm talking about. And so when I'm prepping this guy for his deposition, that's the way I'm going to be handling it. Like, look, dude, you're not a professional journalist, all right? You're just a comedian. You're having fun. Let's try to approach your defense like this. You didn't really call the guy a Nazi as a statement of fact. It was just a joke. It was a statement of opinion because you're a comedian. It's the context. That's how we should be approaching this case. Do you guys follow me? Now, if it was another situation where I was trying to hire him as an expert witness to prove that he has advanced knowledge and skill about false statements, like if I'm a plaintiff and I want to hire him as an expert to prove that the defendant defamed me, then I want to qualify him as an expert as the plaintiff. But you can see that this lawyer is appealing to his ego a little bit to try to get him to admit that he's a smart cookie and he knows he's a journalist and he knows what he's talking about. Give me a bunch of ones if you understand what I'm talking about. Let's go.
Well, I did study media for, as you said, 2 semesters in college.
Okay. So when you were in college for those semesters, part of that included journalism courses?
Part of it included, yes, broadcast.
Okay. You worked for Fox back in the 2009-2013 time period?
I believe so. Time period sounds correct.
Did they provide you any training in journalism?
Objection, vague as to training and vague as to journalism. What do you mean by journalism? You're trying to set my client up. I don't know what do you mean? Okay, you can answer if you know, but I'm objecting for the record.
Experience.
I understand that you did the job for many years. I'm sure you picked up some things, right? But what I'm wondering actually is, as part of your employment, did Fox provide you with formal training in journalism?
Same
They did not
objection.
send me to journalism school, no.
Okay.
And same objection, by the way. And move to strike his answer because I didn't have enough time to object.
Now, at that time, I think it's fair to say that what you were doing for Fox was primarily concentrated on more comedic type presentations. Is that fair?
Vague and ambiguous is to comedic.
No.
So back during the time period when you were working at Fox, would you say you were covering hard news at that point too?
Vague and ambiguous as to time, place, location. What time are you talking about? He's worked at Fox multiple times. What time specifically are you referring to?
Objection form.
Sometimes.
Okay. And then after leaving Fox, you've
Vague as to leaving Fox. It's my understanding, counsel, that Mr. Crowder comes on Fox News as a guest all the time. So you need to be more specific. So
let's start this way. The YouTube channel you had that while you were at Fox, right?
Correct.
And you've kept using
Same
that
objection.
as a platform ever since leaving Fox, right?
Yes.
Am I right that there was a brief period where you weren't on YouTube? Is that right?
Vague, ambiguous, and unintelligible as to brief period. Also, it's leading.
Objection form.
How so?
Or am I right that at some point you either stopped posting to YouTube or were in some way punished by YouTube? Did anything like that happen?
Objection overly broad.
Objection form.
Well, there are temporary suspensions that happen on YouTube, if that's what you mean.
Okay, but in May 2023, you were posting regularly on YouTube?
I believe so.
Okay. So for instance, the coverage we're here to talk about today, that would have appeared on YouTube.
I believe so.
Okay. Now, ever since leaving Fox, say the past 10 years, fair to say that you've begun to amass a rather sizable audience.
Objection vague as to amass. Objection vague as to sizable. Objection vague as to audience.
Yes.
Okay. You understand that as the size of your audience increased, the magnitude of potential harm that could be caused by publishing a false statement about.
Now, Ryan Labs asks, could I say I don't recall? And absolutely, you can say that you don't recall, but that also calls into question your credibility to a jury or a judge later on if it's obvious that these were facts within your knowledge. So be careful about the I don't recall. That's the typical cop response. When they beat the crap out of someone and take their phone and stomp on it, and then they're questioned like 6 months later and they don't recall anything, and they're real smart assy, like most cops are at their deposition. So just be careful about that. Let's go.
Someone also increased.
That's a Hillary move.
And would you agree with me that as that potential magnitude for harm increased and your audience increased, your responsibility as a journalist also increased?
Objection form.
Objection calls for an expert opinion, leading, argumentative. Let counsel, you're harassing my client at this point. Okay. I'm warning you. You need to start narrowly tailoring your questions. You're trying to set my client up. He is a layman. He does not understand these questions. Please rephrase your question. You can answer if you understand. I'm not instructing my client not to answer, but this is ridiculous.
Well, I've never labeled myself a journalist, but yes.
Well, you cover hard news. We can agree with that.
Objection, vague, ambiguous, and unintelligible is to hard news.
Sure.
Leading.
So does Jon Stewart.
Sure, absolutely. Right. And let's make it clear, even today on your show in which you cover hard news, you also do things that are comedic.
Yes.
Okay. Now, you would agree with me, for instance, that the sort of care that a person like you needs to show might be different if you're just, say, talking with a friend at a bar.
Objection, Vegas to care. What are you talking about? Vague, ambiguous, and unintelligible. Leading, argumentative, makes no sense, overly broad.
Versus making an announcement over a baseball stadium public address system. You understand what I mean?
I understand.
Okay. And so when making decisions about how you run your business, I take it one of the things you do consider is the responsibility you have given the size of your audience. Is that right?
Well, but take responsibility regardless.
Yeah, objection again. Vague and ambiguous as to responsibility. What are you trying to get at, counsel? Just ask him normal questions so he has an understanding of what you're talking about.
Of the size of the audience.
Sure, I understand that perhaps even when just talking to a neighbor or a friend at a bar, you might be careful about what you say. But what I'm asking is, when you do your job, part of what you consider in how you create your policies, your requirements, etc., is you understand you're going to be talking to a very large audience and that the magnitude of harm from false information could be very great. Is that correct?
Again, vague, ambiguous, and unintelligible as to the definition of harm, audience, overly broad, argumentative, leading. You can answer if you understand.
There's a lot in that statement. We take care to be as responsible as possible, regardless of the size of the audience.
Okay. Last year, when doing an episode of Louder of Crowder, how many people could you reasonably expect to view it?
I don't know.
So for instance, on YouTube, YouTube tracks the number of views your videos get, right?
So, to a degree, yes.
Okay. Rumble does the same thing. You can see how many people viewed your videos?
To a degree, yes.
Okay. And so that should give you the number of views on Rumble and YouTube will at least give you a minimum baseline of who saw the video. Is that right?
Sounds right.
And then you also know that your materials will quite foreseeably spread via social media, right?
Sure.
You're aware people share your videos.
Sure, yes.
For instance, when getting a video in this case, when I asked for a copy of the video in this case, I was directed to a website that publishes your videos without any of your input, right?
That's my understanding.
Yeah, objection assumes facts, not an evidence. Leading.
Okay. One of the things you offer your audience is fact checking of the news, correct?
Objection, vague, ambiguous, and unintelligible as to fact checking. Are you saying statements of opinion like Mark Zuckerberg, who says that they're actually facts, where he hires some leftist fact checker, somebody at Snopes, to say that it's false when he knows that it's not false, but it's political speech, and then he uses that as a basis to ban your account because it's false, and then defames you and hides behind Section 230 of the Communications Decency Act? Is that what you're talking about, counsel?
Correct.
Okay. In fact, let's bring up tab 1. All right. I want to show you something that was just posted to the website last week.
Look at all those criminals.
And as I think you may remember, we had this deposition.
Look at all those criminals and money launderers who are all now getting caught. Isn't that amazing? Isn't this great, guys? Look at all these criminals over here.
Scheduled for a few days ago. But one of the reasons that we had rescheduled it is so that you could do fact checking at the DNC, correct?
Yeah, that's a portion of it, yes.
Yeah, and vague and ambiguous as well to fact checking, and also to DMC. What are you talking about? What is DNC? Go ahead.
Okay. So, for instance, in this broadcast, you'd be telling your audience, hey, certain claims are going to be made at the DNC, and we are going to use our skills to tell you what is real and what is not. Is that fair?
Objection, leading, vague, ambiguous, and unintelligible as to true or falsity.
Yes.
Okay. So your audience can expect that you're going to be talking to them about matters of truth or falsity, right?
Objection, leading, argumentative. You're badgering my client. he can't be expected to know what that audience thinks or not. He's a comedian, counsel. Come on. Stop harassing my client. Let's get to the point.
Yes.
Do you agree it's reasonable for your audience to expect you to use the same level of care they would expect from any commercial media outlet?
Objection: vague, ambiguous, and unintelligible as to care, duty of care, lacks foundation. You've laid no foundation as to what the duty of care is, counsel. It calls for an expert opinion. You've not laid a foundation for my client to give a proper answer, counsel. So on that basis, you're coming very close to me instructing my client not to answer. But if you understand, if you think you're an expert, you can go ahead and answer, Mr. Crowder.
Objection form.
Yeah.
I mean, I guess what I'm getting at is,
Hey, Kevin.
it's not going to be your position that, hey, I'm just a clown. I'm just a guy who plays dress up. I'm not doing news. That's not what your position is. You do hard news. Correct?
Objection. Same
Depends on
objection.
the context.
Yeah, exactly.
Absolutely.
Same objection. Counsel, what do you mean by hard news? It's vague and ambiguous. It's leading, calls for an expert opinion as to what hard news is. Come on, counsel. Stop badgering my client.
Sure. Like we said, there are some instances where your audience is clearly going to know that you're doing a comedic sketch, right?
Sure.
But your May 8th coverage of the Allen shooting, that wasn't a comedy sketch.
Objection. Leading, calls for an expert opinion, lacks foundation, vague, ambiguous, and unintelligible as to comedy sketch. But you can answer if you understand the question.
I don't know if it included sketch elements. We often mix news with sketch elements, but no, not the commentary on the reporting. No.
Okay.
By the way, that was a terrible answer, guys. So just so you know. Now, a good lawyer, by their objections, obviously their client's going to be able to pick up some of that stuff. If he had me there making the objections, don't you think his answers would have turned out a little bit differently? Give me a bunch of ones if you think that his answers would have been more on point and put us in a better settlement posture. If you think so, I'm just trying to show you how to be an effective lawyer, how to be an effective trial lawyer, how to be an effective litigator. It's almost like being back in the Marines. You've got to be super motivated. You can't be fumbling with your phone. You really have to stay after the task. And it's like, so for me, when I learned how to do objections, I learned from a really good friend of mine at the city attorney's office, as well as an appellate justice and a really good buddy of mine who's a trial lawyer, one of the best trial lawyers in the country. And I basically, we would play games almost like back and forth, boom, 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 and it's funny because now when I have conversations with people and they start giving me evasive answers, I want to start objecting. I can't help myself. Anyways, hopefully you guys understand now the difference. And I'm not saying his lawyer is not effective. I'm just saying that I would have been much more aggressive myself because that's my nature. And I believe that my line of objections would have put us into a stronger settlement posture because that's the goal. You want to settle because these defamation cases, they can go, you don't know how they're going to go. Anyways, here we go.
Let's talk a little bit about how things work at your business. First of all, you're the boss at Louder with Crowder, right?
Objection
Objection, vague, ambiguous, and unintelligible as to boss.
form.
I guess.
Well, I mean, I'm guessing what I'm asking is, if you're doing things throughout your workday, is there somebody who can come to you and says, Steven, no, you can't cover that. You're not allowed to do that.
Yes.
Okay. Who would?
Okay, so what the plaintiff is doing here, guys, I want to coach you through this. Obviously, we're not going to be able to cover this whole deposition tonight, so I'm thinking we do it in parts. Give me a bunch of ones if you'd like me to finish this depo, all the way through. If not, we can just, cut it off, in a few minutes or whatever. But what he's trying to do right now is lay a foundation to establish vicarious liability. Okay, under the ancient common law theory of master and servant, if the master is liable for the actions of their servant during the course and scope of their employment for the master. And so what this plaintiff's lawyer is trying to do is elicit responses to where he potentially can amend the complaint and add in an additional party. And this is really, really important because a guy like Steven Crowder may not have as much money as, say, somebody like Fox News. So like if a manager at Fox News says you can only say this or you can't say that, now he has the ability to amend the pleadings and bring in Fox News, and they're the deep pockets. And so that's what I'm always looking for. Like in a car accident where my client's adversary, the person who hit my client or ran my client over in a crosswalk or killed my client on a motorcycle, and the family is suing this person for wrongful death, if he only has a minimum insurance policy of like 15 grand and he is poor and he's probably going to jail for manslaughter, my client's stuck with the $15,000 policy under California law, right? So what am I trying to do? Guess what I'm trying to do? I want to find out, is this guy a pizza delivery guy? Was he delivering a pizza? Was he working for a restaurant? Was he, on his lunch break or driving to and from work and he's a salaried employee? I'm trying to establish a nexus where I can bring in the employer who's got the deep pockets, right? I'm trying, if he's a cop, maybe he's undercover, right? And maybe he's on payroll, maybe he's on the clock. And the defense to that is frolic and detour, that the person went outside their course and scope, like they went to a strip club and partied. And so that would relieve the employer from liability because of frolic and detour. They detoured from the work task. So that's just a little, hopefully you guys are learning stuff. Let's get back into the deposition.
That person be.
There's going to be a multitude of people.
So there are a multitude of people at Louder of Crowder who have veto power over what you can cover on your show.
No, a multitude of people who have, wise counsel.
Sure, I have a lot of people in my life who have wise counsel. I listen to them and take their thoughts into consideration, but they don't have control over me. And I'm wondering if there's anybody at Louder with Crowder who has control over you.
So objection calls for an expert opinion, leading, argumentative, calls for speculation.
Who says, if you do this, Steven, you're fired. You don't work here anymore.
At Louder with Crowder? No one can fire me.
Okay. And if you want to say something on your show, is there anybody who can stop you?
On my show?
Objection.
No.
Objection calls for speculation.
Okay. You would agree that it would be the usual practice of Louder with Crowder. Let me put it in an easier way. You agree it's your usual practice to verify the accuracy of images you share with your audience.
Objection leading, vague and ambiguous as to the definition of accuracy. Subjects. You can answer if you know the answer.
Objection form.
Can you restate the question? It was telling me that.
Sure. It's if you're going to share images with your audience of news events, right? Things that depict news events, it's your usual practice to verify the accuracy of those images before you show them.
Objection leading, calls for expert opinion. Vague and ambiguous, calls for speculation.
Objection form.
Sometimes.
Okay. Let's make it more specific. When you're going to share an image of a purported mass murder, it would be your usual practice to verify the accuracy of that image before showing it.
Objection, compound, disjunctive, and conjunctive. Vague is to verify, vague is to accuracy. You can answer.
Objection form. And to clarify, Mark, just so for reference, are you referring to Steven individually or Louder with Crowder as a whole?
Him individually.
Yeah, so see, she did it exactly right. Now, you don't have to, by the way, guys, here's something. So if as counsel, like I've been doing also, if you start trying to break down their questions and ask them, did you mean this? Did you mean that? You could actually get sanctioned for trying to make what they call speaking objections. Okay, so it's important to try your best, unless they're harassing your client, right? Or your client's just going off on left field, to try and not make speaking objections. It should be good enough to, unless it's really out in left field, to, it calls for speculation. It's vague. And that's basically what she's saying. She's like, what do you mean? So, she's doing her job. She's doing a good job.
Go ahead.
Me individually, then no.
No. So there are In other words, let's put it this way. If you're going to use on May 8th an image, you're going to show your audience an image of who is purportedly the mass murderer. Is that something you're going to see before you go air? Or is this like a Ron Burgundy situation where you're seeing it for the first time?
Objection calls for speculation. Objection compound, disjunctive and conjunctive, argumentative, leading. If I didn't make that one already, you can answer if you know, Mr. Crowder.
I appreciate the reference to Ron Burgundy. Based on Jim Walcott, actually, Canadian sitcom. There's a difference between breaking news, for example, something that's exclusive to us, where there's obviously very strict, much more strict process of due diligence. If we are the news, then there's reporting on the news that is available publicly, or reporting on someone else's report. So to answer your question, we would obviously ensure that the reporting on that person's reporting is accurate, meaning the original source would be the reporter.
Okay. So in terms of sharing an image, right? I believe what I'm hearing is that if it is your original reporting, you would have a higher level of care than when you are repeating someone else's reporting.
Objection, vague, ambiguous, and unintelligible. Again, as to care, what do you mean by care? And calls for an expert opinion. What do you mean by image? Vague and ambiguous as to image, sharing, compound, disjunctive, and conjunctive. You can answer if you understand the question.
Is that fair?
No, what I'm saying is that there's a difference between breaking news, being the subject of news, and reporting on someone else's news. So use your example like the DNC. That's their story. They run images or claims. So we report on what they are running.
All right, let me give you an example. If the DNC
Right. And by the way, that would be a defense. So if you're reporting on what someone else said and they made a defamatory statement and you're just saying, hey, this person said this about this other person, what do you guys think? Well, that's reporting on something, and that would be a defense because you're not making the assertion. You're not validating the assertion. Now, hopefully, give me a bunch of ones if you guys understand the nuance between reporting on someone's defamatory statement as opposed to endorsing their defamatory statement is true.
DNC puts up an image, right, and says, here is, let me give you an example.
Hey,
Says,
Carol,
the DNC
seeing
puts
it.
up an image of Mount Rushmore and says, this is the Washington Monument, right? You would be able to fairly and accurately report the DNC is saying that this picture is the Washington Monument. That's fine. Right? We're on the same page so far?
Yes, and I would show their picture.
All right. It would be different to say, here is a picture that the DNC is showing that they say is Mount Rushmore. And I'm telling you they're right. That's different in your mind, right?
Objection calls for speculation. Objection calls for an expert opinion. Objection leading.
No.
That's the same thing. So you can report, in other words, this is what I'm trying to get at, is it is okay for you without investigating to report someone else's accusation as truthful.
Objection vague, ambiguous, and unintelligible as to truthful. Objection leading. Objection argumentative. And objection assumes facts, not an evidence that he ever said it was true. This sounds like a trap for the unwary counsel, and I'm cautioning you to stop harassing my client.
To report their reporting as authentic and truthful. Yes, if I believed it was Mount Rushmore and they told me it was Mount Rushmore and showed a picture, I'd show their picture.
And do it without any further checking.
Myself at that moment.
Hold on a minute. Objection vague, ambiguous, and unintelligible to further questioning. What are you talking about, counsel? You can answer.
In time, if I believed it was Mount Rushmore that they were, why would I not believe the DNC?
It's a good question. DNC is an organization you might not always believe, though, right?
That's fair.
Right? They have, in your eyes, they have some credibility issues, I would take it, right?
Objection assumes facts leading.
It depends on who they are.
So in other words, what I'm saying is not all sources are equal, are they?
Objection assumes facts.
That's fair.
Okay. Would you agree that it's important to verify the accuracy of an image of a purported mass murderer
Objection, asked and answered. Objection, this is a highly hostile line of questioning, counsel. It's very argumentative. I'm cautioning you again.
Before showing it to your audience?
Yes.
Okay. Why is it important to verify the image of a mass murderer before showing it to your audience?
Objection, vague as to mass murder. Objection, assumes facts, not an evidence as well.
Well, same reason that it would be important to verify anything.
Why is that?
If you are making a definitive claim, you should do your best to be accurate.
Why?
Because truth matters.
Just intrinsically, or why? Did things happen?
Objection, vague, ambiguous, and unintelligible. Objection, compound.
What can happen?
Intrinsically.
Okay. So you understand, though, that if false information is posted about somebody, is published about somebody, that can have effects on the people who are the subject matter of
Objection, vague, ambiguous, and unintelligible as to effects, calls for speculation, calls for an expert opinion.
those reports.
I would assume so.
Is that something that you can, let's put it this way. If you have news that you're going to report that, if false, could have a damaging effect on someone's reputation or cause them grief, you would agree you need to take special care with that kind of news.
Same objection.
If one is making a definitive claim, they should do their best to be accurate.
Do you know the difference between a primary and a secondary source?
Yes.
Okay, can you help us understand that first by telling us what is a primary source?
Objection form.
But it would depend on the context when you're discussing journalism, or if you're discussing, like I said, commenting on someone else's journalism. Primary source would be the primary reference point, person who's the originator of it, and a secondary source would be a corroborating resource, confirming or also covering it.
Okay, I'm going to kind of give you what I believe would be the understanding that I'm operating from, just so we can talk using the same terminology, right? Like if I was going to tell you, if I'm going to talk about a chair, I'm going to tell you what a chair is, right? Have you ever heard that a primary source would be information that originates from a person or entity that is
Objection, compound, disjunctive, and conjunctive.
either has a firsthand account or is actively involved in the events being
Objection, vague and ambiguous and unintelligible to firsthand account, and also compound again.
reported?
Yes.
Okay. And then a newspaper, for instance, or a academic treatise or
Objection, compound.
some other publication that is writing about an event that it did not have firsthand involvement in.
Objection, this is an incomplete hypothetical and calls for an expert opinion.
That'd be a secondary source. Does that seem fair?
Objection, leading, argumentative.
Yes.
Okay. In terms of, let me do it this way. You would agree you should not display the image of a suspected mass murderer unless the image had been confirmed by someone involved in the official investigation or by reference to some kind of primary source.
Objection, compound and vague as to time, place, and manner.
Do you agree with that?
No.
Okay. And would you agree that you don't fulfill your responsibility in verifying the photo of a mass murderer?
Objection, assumes facts as to having a duty at all of responsibility. Objection as to vague and ambiguous and unintelligible as to the definition of mass murderer.
By assuming that another news organization has
Objection, assumes facts not an evidence that another news organization did anything.
verified the photo.
No.
Okay.
I don't agree.
What are your requirements for publishing a photo allegedly showing a mass murder?
Objection, assumes facts not an evidence that he has any requirements.
Objection form.
So the process would be similar for any stories that in which we're not the primary source, to use your example, would be to find at least one source that would be viewed as legitimate. So usually that's why, when we provide references, we often use left-leaning sources, which we make available every day for every show, and then confirm it with another source where it is available. That would be the process when it's someone else's reporting.
Does it matter who's reporting it?
Objection calls for speculation.
That's why I said you try and find the initial, the most credible source to use as a primary source, because it's a little different when covering news. So to give you an example, if there is a new study conducted on, let's say, medical and COVID intervention, primary source would be one on PubMed, right? The people who conducted the trial. Secondary source would be CNN covering said clinical trial. So same principle, but it's a little different when covering someone else's reporting. So the primary source that we would look for would be as authoritative as available at that time.
All right, so to use that example, if you didn't have access to the PubMed article, but you did have access to a CNN report in which they reported on the PubMed article and cited that PubMed article, that's probably okay to report on. You would agree?
Objection assumes facts not in evidence, calls for an expert opinion, vague, ambiguous, and unintelligible.
I would report according to CNN.
Right. What if CNN didn't have any sort of primary source?
Objection calls for an expert opinion, calls for speculation.
What if CNN just reported a fact, but it didn't have any source?
Objection assumes facts that he knew or didn't know that CNN did or didn't have a source.
That's why I would report it according to CNN.
Okay. And it would be important for you to make clear that you had not been able to verify that.
Objection leading, objection asked and answered, objection argumentative. Counsel, you're badgering my witness. Please refrain from badgering my witness. He's already answered the question. You're trying to get him to change his testimony, and frankly, I don't appreciate it.
Would you agree to that?
No.
Okay. Let's talk a little bit about this incident we're here about today. You understand that on May 6, 2023, a neo-Nazi mass shooter murdered several people at the Allen Outlet Malls.
Objection assumes facts not in evidence, leading, calls for speculation, argumentative. You can answer the question if you know, Mr. Crowder.
Objection form.
No.
You don't understand that right now, sitting here today?
The way you said it, no.
Yeah, objection argumentative assumes facts that he said that he didn't understand anything. Counsel, I don't understand what you're saying. How do you expect a layman to understand?
Help me understand what you mean by that. What is it about that
I don't understand a neo-Nazi mass shooter, no.
Okay.
Mass shooter, yes. No. Neo-Nazi mass shooter, no.
Okay, you're aware that the shooter had tattooed neo-Nazi symbols on his body.
Sure.
You're aware he did it with a right-wing death squad vest. Right, you don't contest any of that.
Objection calls for speculation, argumentative, leading, assumes facts not in evidence.
I'm aware that was reported, yeah.
All right, well, I'm not asking you whether it was reported. I'm asking you whether you can, do you believe that's true? Do you contest that?
No, I don't contest any of the tattoos, no.
Okay. So I guess the hang up is you have a shooter who's tattooed up with a swastika and SS lightning bolts, but you're hesitant to call that a neo-Nazi mass shooter.
Objection assumes facts not in evidence, objection argumentative.
Correct.
And also objection asked and answered.
Okay. You covered that shooting on your show and your website?
Objection compound.
Objection form.
I discussed it on the show.
Okay. And there was an article on the website, right?
Objection assumes facts not in evidence.
That's my understanding.
Okay. And you agree that in covering the shooting, that an image was repeatedly published of my client, Mauricio Garcia, who had nothing to do with the shooting.
Objection leading, compound, disjunctive, and conjunctive, argumentative, calls for speculation.
That's my understanding.
Okay. Let's talk about the show, the May 8th show. In that show, you told the audience that the media was lying about the shooting and that you were going to show them the true information, right?
Objection form.
Yeah, joined. So if she was my co-counsel, I would say joined. but I would say vague, ambiguous, unintelligible, argumentative, leading, calls for speculation.
I don't know if those are my words, but okay.
Well, let's pull up tab 2. All right, I'm showing you now what is tab 2. We'll be offering this as exhibit 2. This is every day with your show. There's also a web page posted called the show notes, right?
Yes.
Okay. And today I'm just going to read the first paragraph here. There was a deadly mass shooting in Allen, Texas, and we have information on the killer, Mauricio Garcia. We'll be refuting the media's lies about the fact that he was a white supremacist and so much more. You see that?
I do.
Okay. So again, you had information on the shooter and you were going to refute the media's lies.
Objection. Assumes facts not in evidence. Leading calls for speculation. That's not what it says to me, counsel. What makes you think that's what it means to him?
Right?
Yes.
Okay.
Wrong answer.
So when viewers tuned into this, they could reasonably expect that you were going to be trying to provide them with true information about the shooter.
Objection. Calls for speculation. Leading, argumentative, asked and answered.
Yes.
And that in providing that information, the information that you had, you demonstrate
Objection. Assumes facts not in evidence. Argumentative, leading.
that the media was lying about the shooting.
Primarily, the media was lying about the shooter. Seems to be the copy written there by Brodigan. Yes.
Sure, let's
Okay.
change that.
Media.
Because the shooting itself is a bigger topic than the shooter, right? Just one person. So let me ask that again.
Objection. Assumes facts not in evidence.
You had information on the shooter, and you
Objection. Vague and ambiguous as to information on the shooter. Calls for speculation.
would be refuting the media's lies about the shooter.
Well, that's a description.
Objection 4.
That's a description.
Same objection. Joined. It's vague and ambiguous. It's also compound, and it's also argumentative and very leading, counsel. Please refrain from badgering the witness. Thank you.
Written by Brodigan on the website, a synopsis of the show. I spoke on the program regarding the media lies and what they were.
Well, let's take a look at that. Let's bring up tab 3. All right, I'm going to show you an excerpt that I want to ask you some questions about from your May 8th show. So let's play that now.
Who the shooter was first. Okay. So you're going to hear the media give you some reports. A lot of what they say is bullshit. All right. Shooter was a 33-year-old Hispanic male. His name was Mauricio Garcia. Mauricio Garcia. Now, the reason that we are pulling this, and you're asking yourself because we make the references available, we're pulling this from Today News Africa, is because it's the only news outfit showing you the shooter's face. You won't find his face in, here you go, NBC, Wall Street Journal, CNN, CBS, Washington Post. They want to tell you that he was a white supremacist,
Yes.
and not see his very Hispanic-looking face.
Right. And a second ago, I actually signaled you because CNN had that lower kind of chyron that said basically that this person was influenced by white supremacy. That's the headline that they're running with right now over.
Yeah.
To make sure they drill it in.
Okay, my first question is, in the lead up to that show, you had been reviewing a lot of media coverage about the shooting.
Objection. Asked and answered. Vague and ambiguous as to media coverage. Vague and ambiguous as to shooting.
Objection 4.
Yes.
Okay. And that review of the media coverage showed that Today News Africa was the only news outfit reported to show a picture of the shooter's face.
Objection. Asked and answered.
Correct?
Can you repeat the question?
Yeah, sure. That review of media coverage,
Mhm.
that showed that Today News Africa was the only news outfit purported to show the shooter's face.
Objection. Compound. Objection. Leading. Objection. Argumentative.
No.
Okay. So when you said we're pulling this from Today News Africa, it's because it's the only news outfit showing you the shooter's face. That wasn't accurate.
Sorry, what was the last part of that question?
That wasn't accurate, what you said in the video.
What I was saying was it was the only place currently with an article including the image of the shooter. Yeah.
Okay.
At that moment in time, as I believed it.
Right. So when you were making that broadcast, your review of media had shown you that Today News Africa was the only news outfit doing that, showing a purported picture of the shooter's face.
Objection asked and answered. Objection argumentative. Objection leading. Objection compound, disjunctive, and conjunctive. Calls for speculation. Calls for an expert opinion.
No.
Okay. I'm a little confused because I thought what you had just said was that at that time, that's why you said that. It's the only news outfit showing you the shooter's face.
Mhm.
Is that right or is that not right?
No, it was the only place at that moment in time.
Objection leading. Argumentative. Again, asked and answered, counsel. Can we move on? We don't have all day.
With an active article, including that image. Of course, there were
Okay.
many other places that had carried it or social media. So at that moment in time, because that was a White House press credentialed reporter.
Well, no, that's all I'm asking about is that moment in time.
Mhm.
And that they're the only news outfit purporting to show the shooter's face. We can agree with that.
Objection leading. Objection asked and answered. Argumentative.
I don't.
Can
I
you
don't
tell
agree.
me the news outfits that at that moment in time were showing the shooter's face?
No, it'd be difficult to remember. It was everywhere on social media and different articles. So
Well, look, I understand.
And on that basis, I would object. Calls for speculation and move to strike the answer because I didn't have an opportunity to object.
It was on social media. Social media are not media outfits, right? Just some random person on
Objection assumes facts, not an evidence. Objection calls for an expert opinion.
social media is not a media outfit,
Objection lacks foundation.
correct?
no, I disagree.
Okay. So if you just came across a random account, they, ultra MAGA guy 567, and you saw the picture there.
Objection leading. Objection calls for speculation as to ultra MAGA. Objection highly offensive and argumentative.
You'd say, well, look, that's a media outlet publishing this photo. Is that right?
No.
Okay. So as far as any other news outlets that were showing you the shooter's face, right now you can't think of any, right?
Objection calls for speculation. Objection leading. Objection argumentative. Objection asked and answered.
I don't remember which ones. Not at that point.
All right.
I remember that one because it was a credentialed reporter.
So what I'm really trying to get to is this line from the show. We're pulling this from Today News Africa. It's because it's the only news outfit showing you the shooter's face. Is that statement true or false at that moment in time?
Objection calls for speculation. Objection leading calls for an expert opinion.
Could have been poorly worded.
All right. So there are other news outfits showing the shooter's face at this point in time.
Objection asked and answered. Objection leading. Objection calls for an expert opinion. Objection lacks foundation. Objection argumentative.
Objection form.
I believe there were.
Okay. You just don't know what they are, right?
Objection asked and answered. Argumentative.
Not at this moment, no.
I can't imagine they played a big role in your decision to use this photo then, right?
Objection vague, ambiguous, and unintelligible as to big role. Argumentative calls for speculation. Objection lacks foundation. You're badgering the witness at this point, counsel.
Objection form.
They could have.
I mean, you can't testify to that today. You have no idea what they are, right?
Objection leading. Objection argumentative. Objection assumes facts, not an evidence.
Objection form.
They could have. I couldn't testify to, for example, fact checks of the DNC on one primary source is used, other corroborating sources, because I don't remember if we check it once or twice with another source. We provide usually one.
Okay.
So it's of equal importance to have other people who do.
What do you mean by that? It's of equal importance to have other people that do. What does that mean?
Meaning whether it's social media, whether it's other news outlets, there are several sources that we'll often check, but one is made available. So if CNN makes a claim and we check it and then we see that Washington Post makes the same claim, well, in the reference, CNN may be the one that we reference.
All right, guys, we're going to stop it at 33:23. 33:23. and we'll come back. We'll come back either tomorrow or the next day. I got to take my son to judo. Look, I really, really appreciate you guys joining me tonight. Hopefully you guys got kind of a basic understanding of how to deal with a defamation claim. I will try to come back tomorrow, do my best. With that being said, if anybody wants to support the channel, please pick up a copy of my book about how I became a lawyer with no law degree or undergrad. You can pick up an electronic version of this book for $19.99 on my YouTube homepage. And again, the super chats and the memberships, anybody who wants to make a donation, even if it's a couple bucks, thank you, Wasamata, for supporting the channel. And if you guys, if you're finding that these are boring, I can cover other stuff too. I've just been getting a lot of emails from people asking me about how to conduct themselves at a deposition from pro per litigants. So that's kind of why I've been doing this. And Dr. Walter says the image looks just like me. Do you guys think this looks just like me? What do you guys think? I don't know. Anyways, I talk about how to become a lawyer on the law study program, where you can study under a judge or a lawyer the original way before the Marxist run education system started creating all these left-wing fairy lawyers that are running all around town. And I'm an old school blue collar worker, small business owner who became a lawyer later in life, and ultimately became a multimillionaire. And I've recovered hundreds of millions of dollars from my clients without having to be brainwashed by the rainbow flag mafia on some safe space college campus. So I'm glad that you had an opportunity to join me tonight on my show. And hopefully if I'm feeling okay, I'll come on tomorrow as well. I do appreciate everybody joining me tonight. And I want to thank Dr. Donna Walter. I want to thank Wanda Mise. I want to thank Liz as well. Life Under the Microscope. Thank you so much for supporting my channel. Thank you, Aunt Paisano. I know it's Pisano, but I say Paisano like you're Italian. And Mr. Osgood, Rhine Labs, Delta Bailey, thank you so much for coming. Brandy Swaney's the best. Thank you for coming. Kevin Bironarski, thanks for joining me. Jody Shiloh and Mia Stero, thanks again. And man, you guys are so awesome. So yeah, you can tell I'm pretty fried. I've been on my back for about 3 weeks, and doing the show has been really, really tough for me. But I have so many of you guys reaching out to me, and I want to thank you for all your prayers and all you guys supporting my channel. It means a lot to me. All that positive spiritual energy means a lot to me. So I'm really, really glad to see all you guys. Hey, who knows? Hopefully these videos will start picking up again. I'll probably have to do more lawyer reaction videos to cops beating people up, and then we'll have like 1,000 viewers like the old days. But in the meantime, at least we got the channel back up, and I'll cover the rest of the Crowder Depot. And I want to share with you really quick, again, his anti-SLAPP brief, so you guys can learn about what anti-SLAPP is. So I'm going to drop it in here. It's on Dropbox. I just dropped it in the sidebar so you guys can learn for yourselves. I mean, hopefully you guys are getting an education. I mean, this is more than you'd ever learn in a law school. Trust me on that. I'll smoke any law professor at any kind of deposition any day of the week. I'll put all my money on that for sure. So anyways, guys, make sure to like and subscribe. Make sure to double tap that screen since we're in vertical mode. Make sure to save, because we never know when the thought police are going to take down this channel. And again, Semper Fi, do or die. No excuses, guys. Go out there every day and make it happen like there's no tomorrow. Love you guys. Take care.